9 Extinction Rebellion activists who smashed 16 windows at HSBC's Canary Wharf headquarters, causing £500,000 worth of damage, and another £500,000 it's estimated for the trial, have been acquitted of criminal damage. And I've received a number of emails asking me to talk about this, so we'll do that just now. And watch this short video clip of them actually filmed in the act. But before we do that, we're here on Black Belt Secrets and just about to tip over 100,000 subscribers. So please do hit that subscribe button and let's get over that threshold. I'll be very grateful for that. I'm very excited because it's going to fall on around about the Floof's birthday, which is an interesting story because we first picked up the Floof on the day that I hit 100,000 subscribers on Black Belt Barrister. So do it for the Floof, if not for me. Let's take a look at this video. As you can see, literally filmed in the act of smashing these windows. Literally bringing a sledgehammer and chisel. No ambiguity as to what they're doing there. They are breaking the windows. So how and why is it that they have been acquitted? Well, this is the very debate of having a trial by jury. So a few free-flowing thoughts since we're here on Black Belt Secrets. This is often referred to as jury nullification, or more properly as a perverse verdict. And this is not the only time this has happened. Certainly not the first time this has happened. It's happened a number of times. You might remember the Colston statue and the defendants who were then known as the Colston Four, and raised very interesting defences. But before we get to those defences and talk about why it might be that they get acquitted for things like this, let's talk about the oath that jurors take. Because when sitting on a jury, jurors do swear an oath that they are going to try the case faithfully according to the evidence. Part of the oath that all jurors take at the very beginning is that they either declare on a faith or they affirm that they will faithfully try the defendant and give a true verdict according to the evidence. And once a verdict has been reached, they are not required and not even allowed to give any reasons for how and why they reached that verdict. It's impossible for anybody to know what went on inside the jury room because it's all private and they're not allowed to talk about it, in the UK at least. And so it's impossible to know for sure what the reasoning was behind any acquittal that might to others seem perverse. And it may simply be that the prosecution failed to convince them to the required standard, which is so that they are sure or beyond a reasonable doubt that the defendants were guilty, or because they simply declined to convict. Now, it would be contempt of court for anybody inside a courtroom, especially the lawyers, to mention jury nullification and to tell the jurors that they have a choice to decline to convict at any time during a trial. That would be contempt of court. Telling you the academics of it here is certainly not, because this is an academic discussion. Commenting on previous trials as to why it might have been the case is also perfectly fine, because it's done and there is no second try. Now, taking, for example, the Colston Four, who were also tried for criminal damage for tipping the statue. In fact, they admitted as much to tipping the statue into the water. One of the imaginative arguments raised by defence was that criminal damage is lawful. In fact, it wouldn't be criminal damage if the defendant believed that the owner of the property would consent to the damage. So, for example, I often use the case when I'm teaching this at law school on occasion, that if I were to smash up my own phone, I ask the question, is that criminal damage? And there's a variety of answers come back from the students, most of whom would agree that it's not criminal damage because it's my phone. But you can understand why some people would still think that it is. But if the person causing the criminal damage would reasonably believe that the owner would consent to that damage. And the excuse and the example I often use there is if it's a hot summer's day, and I do videos like this on Black Belt Barrister, if you're walking past a car and you see a dog or a baby or something else in a vehicle that is blisteringly hot and there's a high likelihood that they will not survive the heat, if you smash the window, are you causing criminal damage? Well, no, because you would reasonably believe that the owner would consent to the damage in those circumstances, because it would be better to save the animal than to not break the window. Now, the argument used for the Colson fall was that the statue was owned by the people of Bristol and that they would have consented to the damage caused. Now, even taking that one defence in isolation, it is now impossible for anybody to determine whether or not a jury acquitted on that basis, that maybe the people of Bristol would have consented to that damage based on the history surrounding the arguments and everything else. So that is entirely possible. It's also entirely possible that they just refused on their own morals to convict them. But that is why it's often referred to as a perverse verdict. It's something that shouldn't make sense and we can't necessarily explain. Just as in this case here, you might say that even though they've been filmed in the act, which clearly on any other assessment, they have caused the damage. But causing the damage by itself is not necessarily criminal damage for all the reasons I've just outlaid. And there are other judgments, such as a Supreme Court judgment, DPP and Ziegler of 2021, providing a possible defence under Articles 10 and 11 of the European Convention on Human Rights. Protesters may be able to argue that criminal convictions are a disproportionate interference with their right to assemble and protest. And again, in the Colson 4 case, it was submitted that the removal of the statue constituted a protest. So again, I don't know what the arguments were raised in this current case with Extinction Rebellion. Perhaps I would expect similar arguments raised, in that it was ostensibly successful in the Colson 4 case, with the arguments presented, and whether or not it was those arguments or whether or not it was purely a perverse verdict and the jury declined to convict, we won't know. But either way, the defendants were convicted, as in this case here. There's a very interesting review of these sort of cases by Exchange Chambers. No connection to me, but I will link that article by Hannah Forsyth in the description below. Please do go and read that. And you'll find that very interesting. And it covers this in a little bit more detail so you can take more time to digest it. But that's an overview of when and how this happens. This gives rise to the debate for and against a trial by jury. Many people will argue for the trial by jury because some people will argue this is the right decision because of insert their personal reason. Other people will argue that it is a good example of why we should not have trial by jury and that it should be by a judge, because almost certainly a judge in similar circumstances would convict a defendant, because as a matter of law, if there is no proper defense, they are guilty. Very often when defendants have admitted to the act, although pleaded not guilty, a judge will still direct that they are to be convicted because they've admitted the act, and if there's no defense, they are, as a matter of law, guilty of the offense. But I hope you found that interesting. Please do remember to smash that like button and subscribe, because I would like 100,000 subscribers for the Fluth birthday. I'm sure on some level she'll be happy and she'll be glad you did so. And her channel's linked in the description as well below, by the way, and you can join us with her on walks, and I'll fill you with some animal lore while we're in the process. But in the meantime, thank you for watching.